Welcome to Privacy Theories and Frameworks. We're going to talk a little bit today about what invasion of privacy is and some of the theories behind some of the policies that are created, especially as they pertain today to things like data collection and data protection. So to begin, invasion of privacy is a very multifaceted tort, and a tort is basically a civil wrong. It's designed to redress a variety of grievances, and these include things like commercial exploitation of an individual's name or their likeness, intrusion on what might be called our private domains, the revelation of intimate information about somebody, and the libel-like publication of embarrassing false information about a person. Now, as you can imagine, the right to privacy here in the United States has been diminishing bit by bit for over 100 years. This is due to things like the growth of government, the growth of the mass media, numerous technological innovations. All of those have led to sort of a shrinking right to privacy. Now, where this all began here in the United States, a lot of people point to the intrusive newspaper reporting of the 19th century. Big city daily newspapers were using a variety of sensational schemes to attract potential readers, and editors would write stories about the lives of the rich and famous so that readers could live vicariously through those lives. This kind of journalism led two Boston lawyers, Samuel Warren and Louis Brandeis, to use the pages of the Harvard Law Review to propose a legally recognized right to privacy. Their article appeared in 1890 and is sort of the fountain from which the modern law of privacy has flowed. 13 years later, the first state recognized the law of privacy, and it grew slowly and sporadically over the next 90 years. The majority of states today recognize some kind of legal right to privacy. Another key landmark moment in privacy law development in the United States was in 1960, when torts professor William Prosser divided privacy into 4 different categories. And here you see them: false light, appropriation, intrusion, and private facts. So let's take a look at each one of these. First, false light. False light is a cousin to libel, and some say we don't even need false light, that libel is enough. False light involves making a person seem in the public eye to be someone that they are not. Some states don't allow false light suits. False light doesn't have to rise to the level, though, of injuring someone's reputation like it does with libel. Again, libel protects a person's reputation. The purpose of false light is to protect a person from emotional distress. In most states, the plaintiff will have to prove that material was published to a large audience, the plaintiff was identified, the published material was false or it created a false impression, the statements or pictures put the plaintiff in a false light that would be highly offensive to a reasonable person, and the defendant knew the material was false or recklessly disregarded its falsity, also known as actual malice. Corporations, businesses, and associations can't sue for false light, only individuals, because only individuals can be highly offended. The main question in these cases usually focuses on the highly offensive element. Defining it is very subjective. In one case, The Sun, a tabloid, published a picture of a 97-year-old Arkansas resident named Nellie Mitchell to illustrate a story carrying this headline: "Pregnancy forced Granny to quit work at age 101." The story was a fictional account of an Australian woman who left her paper route at 101 years of age because she became pregnant during an affair with a rich client on her route. Mitchell, in fact, did deliver papers in her hometown for nearly 50 years. She won her false light suit and, after the newspaper's appeals, was awarded $1 million in damages. Now, since 1967, plaintiffs in false light cases have been required to carry a fault requirement much like the one applied in some libel cases. The case in which this fault requirement was applied to invasion of privacy was the first mass media invasion of privacy suit ever heard by the Supreme Court. In the early 1950s, the James Hill family was held captive in their home for about 24 hours by 3 escaped convicts. The fugitives were captured by police shortly after leaving the Hill home. The incident became widely known and publicized. At about the same time, there were other similar hostage takings in other parts of the United States. Author Joseph Hayes wrote a novel about such an occurrence called The Desperate Hours. This focused on a fictional 4-member Hilliard family that was held hostage by 3 escaped convicts. The book was made into a movie and a play. Before the play opened on Broadway, Life magazine published a feature story about the drama, stating that the play was a reenactment of the ordeal suffered by the Hill family. The actors were even taken to the home in which the Hills had lived and were photographed at the scene of the original captivity. James Hill sued for invasion of privacy. He complained the magazine had used his family's name for trade purposes and that the story put the family in a false light. The Desperate Hours did follow the basic outline of the Hill ordeal, but it also contained many differences. The fictional Hilliard family, for example, suffered far more physical and verbal abuse at the hands of the convicts than did the actual Hill family. The family won money damages in state court, but the Supreme Court vacated the lower court rulings and sent the case back for another trial. The Hill family gave up, and no trial was held. Justice William Brennan declared in the Supreme Court ruling that the family's name and photos had not been used for trade purposes, and he applied the same First Amendment standards from New York Times versus Sullivan libel suit to this category of invasion of privacy litigation, saying, "We hold that the constitutional protections for speech and press preclude the application of the state privacy statute to redress false reports of matters of public interest in the absence of proof that the defendant published the report with knowledge of its falsity or in reckless disregard for the truth." Most authorities tend to think that the Hill ruling will stand as law in most jurisdictions. You have to show actual malice, knowledge of falsity, or reckless disregard for the truth. Let's move to the appropriation tort. In 1902, Abigail Robertson of Albany, New York, awoke one morning to find her picture all over town on posters advertising Franklin Mills flour. 25,000 copies had been placed in stores, warehouses, and other public places. Abigail said she felt embarrassed, humiliated, and that she suffered greatly from this commercial exploitation. She sued for invasion of privacy. She lost her case, but the state legislature decided, because of the huge controversy this case created, to adopt the nation's first privacy law in 1903. Appropriation is defined as taking someone's name, their picture, photograph, or likeness and using it for commercial gain without permission. The appropriation tort actually includes 2 different legal causes of action. One is a right to privacy, and the other is the right to publicity. The right to privacy tort was designed to protect someone from emotional damage. Imagine how embarrassed Abigail felt the morning she awoke to find her picture on all those advertising posters. The right to publicity, on the other hand, is there to help accommodate people for any economic or financial harm they suffer when their name or picture is used for advertising or trade purposes and they're not compensated for it. This protects a property right. Only a person whose name or likeness has a commercial value can successfully allege a violation of their right to publicity. An average person like me would likely be embarrassed to find her picture on a box of cereal, but it would be extremely difficult for me to argue in court that General Mills was actually promoting its cereal this way because kids all over America want to eat what I eat. Next, let's move to intrusion. We start with this premise. It's illegal to intrude physically or otherwise upon the seclusion or solitude of an individual. This is different from trespass. Trespass is usually defined as the intentional and unauthorized entry onto land or property occupied or possessed by someone else. An illegal intrusion can be accomplished without physical entry onto private property. It could be done by taking a photo of someone who's in a private and secluded location. And the law governing the two actions is different. The most important element in an intrusion case is what the courts call a reasonable expectation of privacy. This is a very subjective determination in many cases. But if a court rules that a plaintiff did not enjoy a reasonable expectation of privacy when the defendant gathered or attempted to gather the information at issue, the intrusion suit will fail. An illegal intrusion can occur in many ways. Eavesdropping to overhear a conversation could be an intrusion. Gathering personal information from someone's private records. Use of a telephoto lens on a camera to photograph someone might violate the law as well. A reporter who sits at a table in a restaurant and eavesdrops on the conversation at the next table is actually not committing an intrusion. If other diners can hear the conversation, the speakers did not enjoy a reasonable expectation of privacy. If, however, the reporter hides in a closet in the subject's office and listens to a conversation, this would be an intrusion. A person can't claim a reasonable expectation of privacy if he or she gave consent, for example, for someone to be on their property. These are the elements that you would need in order to prove an intrusion case. You had that reasonable expectation of privacy. Someone intentionally intruded on that, and that intrusion would be highly offensive to a reasonable person. And now let's move to the private facts tort. We start with this premise for private facts. It's illegal to publicize private information about a person if the matter that's publicized would be highly offensive to a reasonable person, and it's not of legitimate public interest or concern. Before an invasion of privacy suit here can be successful, the plaintiff has to show the material publicized was indeed private. What happens in public is considered public information. When the Associated Press reported the identity of a victim of a sexual assault who testified at the sentencing hearing of a molester, the young man sued for invasion of privacy. His name was not in court records and had not been made public before the hearing, but the testimony was given in open court. The Fourth U.S. Court of Appeals ruled in favor of the news-gathering agency, saying, "We cannot understand how the voluntary disclosure of information in an unrestricted, open courtroom setting could be anything but a matter of public interest." If it's settled that private facts about a person's life have been published, then the court has to ask, would the publication of the material offend a reasonable person? And was the published material of legitimate public concern? If it is, it doesn't matter how offensive or embarrassing the revelation is. There was no invasion of privacy. Many years ago, a woman named Dorothy Barber had an unusual disorder. She ate constantly, but still lost weight, and was admitted to the hospital. Journalists were tipped off and came into her room, taking pictures against her will. Time magazine ran a story about her, referring to her as the starving glutton. Mrs. Barber sued for invasion of privacy and won. The judge said the hospital is one place people should be able to go for privacy. The story was also very offensive and almost mocking. It made Mrs. Barber look like a freak and would highly offend a reasonable person. So those are the 4 torts of privacy that we know them traditionally. Here's some additional regulations and information concerning privacy. In 1974, Congress enacted the Federal Privacy Act, and this regulates government databases, and it found that the right to privacy is a personal and fundamental right protected by the Constitution of the United States. It's generally acknowledged that the U.S. Privacy Act represented the first official embodiment of the fair information principles and practices that have been incorporated into many data protection regimes. There is, however, in the United States, no single federal privacy omnibus law. Moreover, there is no designated central data protection authority in the United States, although the Federal Trade Commission has primarily assumed that role for consumer privacy. The FTC is independent of the President and is not obliged, although it's encouraged, to respect the administration's perspective on the proper balance between the costs and benefits with respect to protecting data privacy. The chair of the FTC is designated by the President and may be removed as chair, although not as one of the FTC's 5 commissioners, at the discretion of the President. Other advanced economies such as Canada, Israel, and Japan have pivoted toward creating privacy regimes that are compatible with the EU's GDPR, rather than with the patchwork approach of the United States. This puts U.S. companies at a bit of a disadvantage globally, as emerging economies adopt simpler and often more EU-style comprehensive approaches. Privacy and data protection are balanced in the United States in accordance with other rights and interests that societies need to prosper and flourish, namely economic growth and efficiency, technological innovation, property and free speech rights, and of course the values of promoting human dignity and personal autonomy. The most significant factor in counterbalancing privacy protections in the U.S. is perhaps the right to freedom of expression guaranteed by the First Amendment. Preserving free speech rights for everyone certainly entails complications for a right to be forgotten, since one person's desire for oblivion may run counter to another's sense of nostalgia, or for some other desire to memorialize the past for good or ill. If you were reading this on a website in Europe now and thought it was inaccurate or excessive, you would have the legal right to request that Google remove it from its search results, thanks to a 2014 European Court of Justice ruling. The court, which is charged with interpreting EU law, determined that Europeans had a right to delist, meaning that individuals, corporations, and even government officials could request that material be removed from Google's search results if it's deemed inaccurate, inadequate, irrelevant, or excessive, and not related to discourse regarding the public interest. While 88% of Americans do support this so-called right to be forgotten, the prospects of similar legislation or court decisions in the U.S. are dim. Let's talk a little bit about data breaches. Many information security experts remember 2014 as the year of big breaches, and with good reason. In addition to several high-profile hack attacks like Home Depot, the year included a number of lesser-known incidents that nevertheless resulted in significant theft of records. When your business experiences a data breach, you need to notify law enforcement, other affected businesses, and affected individuals. Most states, the District of Columbia, Puerto Rico, and the Virgin Islands have enacted legislation requiring notification of security breaches involving personal information. In addition, depending on the types of information involved in the breach, there may be other laws or regulations that apply to your situation. If names and social security numbers have been stolen, you need to contact the major credit bureaus for additional information or advice. On the following slides, you'll see a sample notification letter where you can simply fill in the blank. And it starts with this: we value your business and respect the privacy of your information, which is why, as a precautionary measure, we are writing to let you know about a data security incident that may involve or does involve your personal information. The data access included this. To our knowledge, it didn't include this. We value your privacy. We regret it occurred. We're conducting a review. We'll notify you if there are any developments. Here are the security measures that we've implemented to keep this from happening again. We're working closely with these parties. Please review the letter and the attachments for further information on steps you can take and contact information for additional assistance. On August 15th of 2017, the FTC reached a settlement with Uber regarding allegations that the company had misrepresented its cybersecurity protections and engaged in unreasonable cybersecurity practices. The settlement sheds greater light on what the FTC means by reasonable data security measures it expects that companies will take. Uber suffered a breach of its driver's location and other data and was the subject of 2014 news reports that alleged Uber employees could gain access and use its customers' personal information, including precise geolocation data. The FTC settlement clarified the core elements of a reasonable data security program, including restricted employee access to sensitive data, multi-factor authentication for remote access, and encryption of sensitive personal data both in transit and at rest. Data is the lifeblood of today's digital business and society. That's what everyone says, and yes, it's true, yet people are not the data. They are the lifeblood of the present and future of business and society. They matter, and we use data because they matter to us. We need to care more about data because we care about people. So in crafting policies, it's always important to remember the people behind the data.